One and all. We all have name tags and all of that, but I'm going to quickly go around and have everyone say who they are. But first, I want to welcome Mr. Langus, who is our 15th appointee to the committee, and welcome Joe Levine, who had who had to miss our first meeting, but glad you're here and welcome.
Thank you.
And Stephen Graham.
Oh, and Stephen. Hi, Stephen, from the Downtown Association. Glad to have you here, Stephen. So with that, let's go around and introduce. I'm Reed Shockey, and I'm chair of the committee.
Megan Dunn, vice chair.
Tom Norcott.
Dave Koenig. Claire Olivers.
Angie Sievers.
Jim Langus.
Walter White. Bob Bolerjack, city liaison to the committee.
Jim Miles, Everett City Attorney's Office.
Stephen Graham.
Erica Temple.
Chris Adams.
Joe Metzger-Levine.
Terry Betchwell.
Michael Swanson.
Okay. And let's see, we're going to have our city attorney friends speak to us here in a minute. Ramsey's in the back. Let's see, we've got a couple of people in the back of the room. Do you want to introduce yourselves real quick?
David Simpson, former city councilman with City of Everett.
Deb Williams, Everett City Council offices.
Lois Blanching. I'm just here as a member of the League of Women Voters.
Okay, well, welcome, all of you. Okay, we all have the agendas in front of us, or you should. And if you do, could you look at them real quickly and let me know if there's any items that you would like to add to the agenda for discussion today. You'll notice under item 6, we've got a public hearing that we will convene at 5:30. And however long that takes, at the conclusion of that, we'll get back to whatever's remaining on the agenda. Okay, if I don't see any additions right now, of course, you can bring that up anytime you think we need to add something on there. I'm going to put Jim Langus and Joe Metzger-Levine on the spot here because the last time we all met, we gave a few comments about why we're on the committee and what our interests are. Jim, you're the official newbie. Why don't you?
Thank you for inviting me to participate.
Mm-hmm.
I appreciate that. I've resided in the city for most of my life. My employment has included education and teaching and coaching and vice principal high school work and administration management work in a couple of different districts, and also I've spent 19 years working with 2 city administrations and city councils, and currently I have some private consulting and contract work. Yeah. Thank you for inviting me to participate.
Okay, Jim, and thank you for joining. You can, I think, blame Claire Oliver. He raised your name initially, so thank him or blame him. So, Joe, why are you here?
I am here because I love our city and I want to make sure that it's taken care of. I deal with teenagers all day, and it's kind of fun to be with adults and challenge myself to look beyond dealing with adolescents. And I was on the charter review in 206 with Reed and some of you, and it was a really interesting project. And so I decided to put my name in and see if I could be involved again. So I'm happy to be here.
Great, welcome. And Stephen, I promise I will not forget you a third time.
Well, I'm honored to be a part of this. I've been in Everett almost my whole life as well. I run the Downtown Everett Association, so I'm just very passionate about what's happening here and things changing, and wanting to kind of be in the know at the very least. So I plan on being here for pretty much ever. And as we all know, this doesn't happen very often, so I'm just excited, kind of fascinated to learn a little bit more about the process and take part in it.
That's great. Okay. Let's see, Mr. Bolerjack, do I turn to you now to go over staff updates? And
No, yeah, well, there's approval of the minutes from the last meeting.
thank you very much.
Next order.
I move we approve the minutes for the February 11th meeting.
Moved by Tom, seconded by Joe. Joe, I'm not sure you can do that.
Oh, I can.
Yeah.
Sorry. I'll second that.
Okay, thank you very much, Michael. Moved and seconded to approve the minutes of the last meeting. All those in favor say aye.
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 Opposed? Carried. Now,
Okay.
I think you have an introduction to make.
Right. Well, first of all, as the committee might remember from the last meeting, you have a budget with which to hire some help for things that you need to do. Jim will talk about a list of qualified attorneys in a moment, but first I wanted to introduce a person who's helping with clerical work, and she's in the back, Lisa Harrison. She's done some work part-time for the city in the past with the neighborhoods, so she's well qualified for this, understands what you all are up to and what the importance of this is. So she'll be taking notes, taking minutes, circulating some emails to you and whatnot, so you'll see her name popping up in your inbox from time to time. So glad to have Lisa on board.
Yep.
And Jim?
Thank you. At the last meeting, we did talk about your $25,000 budget and indicated as part of that you could allocate some resources towards an independent counsel. I think it was the desire of the group to rely upon the city attorney's office to the extent that that works for the group, and there's a conflict or whatever, certainly go to outside counsel. I was asked to provide a list of local attorneys who specialize in municipal law. So I think you've all been provided the list, and it really starts out with the attorney in town that specializes in municipal law, and that's Brad Cattle, Anderson Hunter. Outside of Brad, there are other attorneys here. They may be aware of other attorneys that specialize in municipal law locally. I am not. So we did provide some additional names. The Weed Graspa firm out of Snohomish, they do municipal law as well. In fact, I think Tom Graspa last time served as counsel to the committee. And then provided a few additional attorneys out of Seattle that we've all worked with and have some confidence in. The Ogden Murphy Wallace firm, Foster Pepper, and the Pacifica Law Group, they all have attorneys that specialize in municipal law. So that is the report.
Now, excuse me, this person would be somebody that we consult with as needed, when needed, as the situation arises, right?
I think that's how you described it last time.
Okay.
Yes.
And what does this committee designate that person now, or is this for our information, or do we need to make a decision now on who it would be?
I think that's really up to the committee. Depending upon the nature of the issue that you ultimately want the attorney to address, it may be a different attorney. It may be hard at this point in time to designate a certain attorney, but it's your choice, and I'm sure that some of the attorneys here might want to weigh in on that.
Okay.
I would agree completely. I think it'll depend on the issues that come up, and then we'll need to have a conversation about doing the right choices at that point.
Okay. So if we get through the whole proceeding, we finish our work and not having needed a particular attorney for a particular issue, we're good to go. But if something comes up at that point, we'll bring out this list and we'll so designate. Does that's appropriate if the committee agrees? And does the committee agree with that? Okay, that's the way we're going to do it. So tuck this away in your notebook and, yeah, Tom?
The $25,000 we can use for other professional services and administrative services other than lawyers, right?
Is that correct?
Yes, that is correct.
Okay.
Mr. Chairman?
Yes.
Is the minute taker one of those people that we're using some of the money for? And I wondered, do you want to introduce that person? Or,
That's Lisa.
Yeah.
That's who I
Yeah.
introduced earlier.
Okay, sorry, I missed
Yeah,
that part.
yeah.
And
And she is part of that budget.
that's part of the same 25,000. Okay, gotcha. Yeah, thank you for that, Terry. Okay, so that's what we're going to do. So take this sheet with the names on it, tuck it away in your notebook, and if we need that assistance, then we'll work off that list. Okay, item 4. Okay, we're going to have a presentation by Ramsey Rammerman on the Open Meetings Act and public records issues, so that we all do things appropriately and don't speak out of turn and meet all the requirements. So Ramsey, do I just turn it right over to you?
Good afternoon, everyone. Again, my name is Ramsey Rammerman. I'm Assistant City Attorney in the City Attorney's Office and advise on open government issues. You should each have a handout. It was with the cameras, it was too confusing to try and run a PowerPoint, so we're going to work off my PowerPoint, but you have a handout form. We're going to talk about the Open Public Meetings Act and the Public Records Act. Both of these sections, though, have a very similar intent section, which really, I think, should set the stage in looking at what we're doing with these laws. They tell us that the people of the state do not yield their sovereignty to the agencies that serve them. They insist on remaining informed, and the chapters will be liberally construed to fulfill those policies. So I'm going to just be touching on a couple of the issues that I think are the most relevant for your purposes. Obviously, there's a lot more that goes into the law, but really it's to help to make sure that we're capturing the information that you all generate in this process to make sure that that is also available to the public. So if you turn to the next page, I want to first talk about just the broad definition of public record under the Public Records Act, because that's going to affect what you need to be paying attention to. The statute itself has a somewhat vague but broad definition of any writing that's related to the conduct of government that's prepared or owned or used or retained by an agency. The courts have looked at this and say basically nearly any conceivable record becomes a public record. So really just to give you some ideas and thinking to make sure that you're considering all possible records. What is a public record? Well, first, it starts with everything that you could imagine is a writing. If it can communicate information or retain information, it's a writing. And so if it's generated in this process, it's going to be a public record. So it's going to cover emails, text messages. It's going to cover any notes, however informal. Drafts are going to be public records, pictures, videos, calendars. It goes any type of electronic file. And it's important to note, too, that even if we have an electronic copy of a record and a printed copy of a record, those are going to be two separate records. And so they're all going to be public records. And then even on things like your notes, if you take any notes on this handout, that'll be making it a unique public record. So it's really the law is going to cover pretty much anything that you touch in this process. The law is also clear, turning on to the next page, that the location of the record does not matter. Wherever it's stored, if it meets the definitions. The real test that you need to be thinking of is if this record was provided to you or you created it while you're acting in your capacity as a member of this committee, it's going to be a public record wherever it may live. And so it can be, if it's on your computer, that doesn't matter. If it's a personal computer, personal cell phone, if you were acting as in your role as a member of this committee at the time, that's going to make it a public record. So with that, you want to be cautious thinking about how you are generating records. If you're at all using email, it might be worth it to get a new Gmail account you can get for free just for your role on this committee, so you aren't mixing in public records into your personal email account. And that's very easy, easy enough to do. But to help manage that, once you do that, we'd recommend and strongly recommend that you make sure that anytime you're sending an email, copy Bob Bullerjack on it, and that's so that then the city is going to have a copy of it. And if you get an email and you don't see Bob's on it, forward it to him. And that way, the city will have kind of the master set of emails at least. And that's going to help too, because although everything is a public record, not everything has to be retained forever. And if we turn to the next page, if you've provided a copy of the record to the city already, and you don't have any further use for it, and you haven't been told that there's a pending public records request, which is important, but assuming that the city has a copy, you're done with it, and you haven't been told there's a public records request, then you can get rid of it. And it definitely, as you go through this, we're going to want to try and thin out what you keep, because it's a public record if you keep it, and if you're keeping a copy of it, it's a unique public record, because every copy of a record has unique characteristics one way or the other. And so, again, so if you don't want us to be bugging you for the next 10 years, asking you for a bunch of public records, at the end of the process especially, we'll want to go through and make sure we get everything to the city, and that you don't need and get rid of it. So forward it to the city for anything of substance. There's one other category of records which the city probably does not need, which are just real drafts and notes. Their retention value expires once you don't need them anymore. Once you've finished a final document, again, those can be disposed of. But again, once you don't no longer need them, as long as you don't need it anymore. So I think the one way that it'll make your time a lot easier is working with making sure that we have copies of everything of substance, and once you're done with it, you don't keep it. So everything's a public record, and I think managing to try and keep it, we can use that process. Just because it's a public record doesn't mean it's necessarily subject to disclosure. There are some exemptions in the Public Records Act. There's probably only two that are going to be particularly relevant for this process. The first is the deliberative process exemption. This is a very temporary exemption that says while a body is contemplating a decision and exchanging ideas and recommendations, those pre-decisional records don't have to be disclosed until a final decision is made. Once a final decision is made, then even pre-decisional records will need to be disclosed. So there may be, if we get public records requests before the process is over, we may have to look and ask, what was the role this record was playing. We'll work with you on that. The only other one I'd see that would apply would be attorney-client privilege. If you guys do get some legal advice and it comes to the point where that is something that needs to be kept confidential, that can be done. But otherwise, the vast majority of what you all will be doing will be public, and you should keep that in mind. Anything that you write down can end up on the front page of the newspaper, and just keep that process in mind. So public records, very broad application. The other law that's particularly relevant is the Open Public Meetings Act. This body does count as a governing body under the law, which means it's subject to the Open Public Meetings Act. And with that, everything you do as a group, if it involves a majority of you, is going to be subject to the law and needs to happen in a public meeting. The public has a right to observe your discussions and deliberations. The public does not have a right to speak at a public meeting. That's something that you have the discretion to authorize, and I think the process you guys have worked in tonight is one of the public hearings you're having. But at other meetings, when you haven't set up a public hearing, just because the public's here, they don't necessarily have a right to comment. That's something that you as a body have the discretion to control. So a meeting, just what is a meeting? The law is very broad. It defines a meeting where action occurs. It doesn't require final action, it just says action. So what's action? If we turn now on to page 6 here, action is broadly defined to include both, the final vote, but also the preliminary stuff. Any discussion or deliberation is going to qualify as action, as long as it involves a majority of the governing body. And therefore, anytime there's the majority of you talking, that is going to be a meeting. It's that simple. With today's technology, though, you have to beware of the serial meeting, which is something that can get people in trouble. A serial meeting is a series of communications that don't involve a quorum individually, but collectively it adds up to a quorum. So it's going to be a telephone tree or a series of email exchanges or some conversations between intermediaries. Anything like that where there is a collective effort to have a discussion of an issue involves a majority will be considered a serial meeting. A couple examples that we've seen in the relative recent past, City of Seattle, front page of the Seattle Times had a great article with the mayor declaring he was going to have an illegal meeting. He didn't quite word it like that, but he was going to go around individually with each council member to get their thoughts on budget cuts so that he could get some ideas. That's the type of thing that's a serial meeting. Yakima had an interesting one. It was a private citizen who was gathering, 4 council members all on the same page through a bunch of email discussions. That amounted to an illegal serial meeting. They can happen in a variety of ways, but the point is that there shouldn't be any efforts outside of this room to be discussing with the majority of folks on what's going on. Any of the discussion should take place in here, and certainly if there's any effort to reach a collective intent outside of that would be a very clear violation. And so we want to be careful on that with email discussions. Email is not a place for you all to be discussing stuff with each other. It's just, with the Open Public Meetings Act, there is simply no way to have a legal electronic meeting through email. And if you start to have a conversation, and with everybody involved, that once you've got a majority chiming in, you're going to have an illegal meeting, and we obviously don't want that. So really the discussion should be in this room or at the meetings when these happen is where anything of substance should be happening. If there is a violation of the Open Public Meetings Act, there's a $100 fine for each individual who intentionally violates the law. But the more important thing that happens is that it makes any of the actions that are taken, at least the final actions, void, and could be served to undo everything that you're doing if it was deemed that there was some crucial illegal meeting in the process. It could make us have to start over. Or, depending on when it came out and what exactly that decision was, but it can have various serious effects on it. So, again, it's something definitely to take seriously. The substantive discussion should be when you're all here in an open meeting. There are, again, like the Public Records Act, there are some areas where you can go into private executive session. The only one that I would see that likely to be relevant here would be, again, with speaking with an attorney. If there's a need to get to understand the legal consequences of a decision that you're considering, you could go out. We could have an executive session. We'd have to do all the appropriate announcements and such, but we could go to. That's the one area where I see could be relevant. When you do go in executive session, though, it's just for discussion. It's not for voting, not preliminary voting, no straw voting. No, it really is just for getting that legal advice. And what is said in executive session is confidential as well. But so that's just kind of, I think, obviously a very quick overview. And as you think this, you have my contact information on this handout. If you have specific questions, Again, the thought is this is a public process. The public has a right to observe what happens here, and they have a right to observe everything that happens in the process. And so if you keep that in mind, I think that you'll keep us and you all out of trouble, and that'll be good. And if y'all have questions now, I can take those, or you have my contact information.
Okay, questions of Ramsey?
Okay, well, thank you all very much.
I may have one
Yes.
or two. Just for clarification, did I hear you say that, using me as an example, I've got my own computer and I create a Word document and I put notes on that Word document. I don't share it with anybody. It stays on my computer. But it helps me try to stay organized on things. So it's notes to self. Are those discoverable?
That would very likely qualify as a public record. Depending on the nature of the notes, they may be pre-decisional, they may be not depending on how you're communicating them, but I would expect them. They would be public records, probably subject to disclosure. But as preliminary notes, they also don't have any retention value. Mm-hmm. And so once you don't need them, assuming there's no pending request, you can get rid of them, and that's fine. And that's really, I think, a way a lot of that type of document is resolved because it does seem to have a personal aspect to it, but you're doing it in your role as a member of a governing body, as a public entity, and that would make it a public record.
Okay. And I think one of the important messages is by your presentation, people shouldn't think you can't make notes to yourself or create documents on your computer. Just recognize that they're all discoverable potentially, right?
Yeah, and,
So,
we will want to, at the end of the process, get copies of everything and have you purge stuff unless you want to keep it. But do keep that in mind and keeping your records organized so that everything can be found so we don't have anything fall through the cracks too. But I do think a lot of your personal notes are the type of thing that don't have retention value. I don't want to dissuade you from, doing what you need to do to work through the process.
Yeah.
But just do be aware of that.
Yeah, don't count on me to keep everything up here. So but this also segues into my next question, and that is retention period. This committee is done with its work. It's delivered its report to the city council, who will then take it under advisement, and then they'll make whatever decision they make. Through that process, when this committee's work is done and the report goes out the door to council, at that point, can we get rid of our documents, or do we have to wait for the council to complete its process before we get rid of the documents?
So under the theory that you will have given anything of substantive use to Bob, then you can get rid of your own stuff, because everything you're going to have is going to be a duplicate copy, or it's going to be personal notes.
But I'm thinking of that notes to self thing on my personal computer.
That's fine to get rid of. It's destroy when obsolete, and so that's that type of document can be destroyed when obsolete. And once you've done you've finished your product, that's really a judgment call you can make. We will, we would encourage you to get rid of stuff once, at least once the process is fully complete, if you haven't given it, because if you don't get rid of it, it remains a public record. And if you want to keep it for posterity, that's certainly a choice you can make, but it's a public record. And so we need to have some type of, maybe you can give us a copy and we can put it with the rest of the file, and then but as long as you keep it, it's still going to be a unique public record. So just keep that in mind.
So I have excuse me.
No,
I have one-on-one conversation with a citizen for the City of Everett about the Charter Commission. So that's something is that outside of these?
That's fine, because it's just one of you. If it was a majority of you meeting with a citizen, that would need to take place in an open public meeting. And if that citizen was going around and says, hey, I've talked to 7 of your other members and they all agree with me, don't you agree with me, that could be a problem. But if it's just the input, I mean, that's part of your role, is to get the public's input, and that is perfectly okay. It's just really the real thing with the Open Public Meetings Act and serial meetings is avoiding any collective intent. And so you aren't going to do it on accident. You're going to know when it's happening, because it requires a collective intent. But just, does that make sense?
Yes.
Okay.
Thank you.
Other questions? All right, Ramsey, thank you very much.
Thank you all very much.
We'll do our best to behave ourselves here. So. Okay, as I said before, in about half an hour or so, wherever we happen to be, we'll take a break and or we'll start the public hearing, if you will. But for the next half hour, and maybe after we reconvene, we want just to have a free-flowing discussion about issues on your minds with regard to the charter. And I for one don't want to restrict the discussion. I think we just talk about, and you'll notice that Bob and Lee had forwarded the committee's report from 10 years ago, and I think everyone knows that that was corrected. They sent us every odd-numbered page, but that got corrected. So you should all have a copy of the report that was presented 10 years ago. Certainly discuss that. But just let's have a discussion about things that might be of concern to us with regard to the charter. Bob, I'm going to start off. I think you know what we're going to start off with. I had asked Bob to talk to the city administration, departments, and whatever about anything over the last 10 years that presented itself that had some relationship to charter issues, charter interpretation, or whatever. If that's what you were going to report on, go right ahead.
Yeah, and really very little response. There were no what I would call substantive burning issues amongst department heads as far as proposed charter changes. Just some technical things, mostly dealing with finance issues in Article 3. Mentions of warrants are out of date. We don't issue warrants anymore, just checks. There's a list of banks who the city should do business with. The majority of those banks are now out of business, so we'd want to change that. It really just eliminated, I think, would be the preference. So for that stuff, we can draw up some proposed language for the committee to consider. But that's really it. There were no other big burning issues.
And I want to raise first a question and then confirming something for me. The question is that if we present a report to the City Council and the City Council, well, first of all, I'm going to ask, what are the options available to Council once they receive our report? And if something that we send to them they feel is valid for discussion, does any change automatically go on the ballot to the voters, or are there changes that the council can make without a public vote? And then that's going to raise what I need confirmation on. I was on the committee 10 years ago. I'm not sure Joe was on it and others. And I don't, quite frankly, remember what council did with our report 10 years ago. And I think, Joe, if I can, you're probably going to hear at least one comment that there was one issue that we expected to see changed in the charter and was not. And what happened to that report? And could you confirm that nothing went on the ballot 10 years ago?
No, lots. Several issues went onto the ballot, and they all passed. So I don't know how many out of how many that the committee proposed. I wasn't with the city at that time, and I don't know.
Hey, Bob, is that information available somewhere?
Where I found it, I found it on the county website under the 2006 election, just to see which, and I think there were about 10 issues, and they all passed by the voters.
Could you make copies of that ballot proposition available to the committee?
Sure. Yeah.
Yeah, Jim Miles. Just as a reminder, by charter, this committee work is advisory to the council.
Right.
And so, and I think by language in the charter, once you submit your report to council, your charge is complete. And at that point in time, it's really discretionary with council as to what happens to that report and what goes on the ballot. If anything goes on the ballot, it's totally discretionary to them. I mean, they could take yours, carte blanche, and move it forward. They can edit it, do whatever they wish to do. But my sense is that last time, the vast majority of what came forward went forward on the ballot. But we can certainly get what was proposed and what actually went, so you can see the comparison. But it is discretion with council.
So everything from Scrivener errors up to the biggest issue you could think of, if it's going to change, it gets referred to the voters, right?
Correct.
Okay. Joe, can I pick on you to kick off the next part? Because I think you have a question about that.
Yeah. I think Jim had a question.
Oh, Jim, I'm sorry.
can the council include other matters that haven't been put forward by the Charter Review Committee as well for ballot issues?
Yes, the council
Thank you.
has that authority.
Thank you.
Okay. Joe?
Yeah, Jill Metzger-Levine. I remember specifically talking about gender issues in here, like if you look at Article 2, Section 2.1, it says councilmen, and then as you go down, it's he in Section 2.2, unless he shall. I remember having a conversation about how that we were going to change it to be gender neutral, and I don't know where that went or if there's any way to find out what happened with that. So, and that's throughout the whole document.
Came up at the last meeting.
Oh.
And
Yeah, it was I think it was like an amendment in the back that actually talked
That he shall mean he or she.
Okay, so that's what I wondered. I thought I read something and I could not find it again. Does anybody know where that is? So they just did a generic, isn't it better for the document to try to change all the grammatical components, especially in this day and age, or is it better just to have a, whatever you want to call it, a statement?
I guess as being an observer last time, it was my impression that it was the intent of the committee that the change that you are suggesting actually occur.
Yes.
And instead, it became a very generic reference in the back.
Okay.
So the committee could certainly propose that it be done like you wish it be done.
There you go. Yeah.
And that's not a difficult task to do.
Okay. Because I remember really specifically that we were pretty adamant that we wanted to see it changed throughout, not just a reference. So, okay. I don't know if it's something we want to talk about, or I just wanted to bring it up as we began because it was throughout the whole document. So,
Well, I might suggest that as we go through this discussion, if there are items that, get a lot of head nods around the table, maybe we could just list those, begin to develop a list. And yours, using your example, yours might be the number one, and that is, in fact, change the language in the charter to be gender appropriate, as opposed to an index in the back. So we award you the certificate for coming up with the first possible suggestion there. That's not to say we all agree with it, but it helps us organize a list that towards the end of our discussions, we can tick through it and say, okay, what do we think about this list? So,
May I ask a question? So
Yep.
this is 62 pages long and everything is doubled. So is there a reason that this is the way it's written? Because every section is repeated.
We sent everyone, that was the way that the website that we subscribed to, it had a bug in it. And so for us and other municipalities, that was happening. It's since been fixed.
Okay.
And I believe we emailed a new,
I got one.
You
better
did.
one.
Okay.
Yeah.
So the one that we have here in our binders is not.
That's not the official,
accurate
nope.
version.
No,
Thank
it's
you.
just the way it printed out from the web.
Is there a way that we could have the accurate version printed out for us?
Yes.
And then we can have that in our binders.
We'll have that
Thank
for you. Yeah.
Terry?
Yeah, I was just going to add on to what Joe said, that I think some of the terms could be gender neutral, not referring to either, and like council representative or that kind of thing. And then I've seen it before where you just sort of go back and forth. So the first chapter you use the masculine and the second the feminine. So I think that's kind of a nice way to balance things out. I do have some comments that I wanted to bring up, but it seems like mine are more about the process and belong under the number 7, or should I?
Let's see. You mean about the process we're going through?
Right.
Or,
Yes. About the process, not.
well,
not
I'll tell you
about-
what. Why don't you go ahead and,
Okay.
and ask?
Well, I mean, last time when we met, we talked about the number of days, possible meeting nights between now and the date it was ended. And so I'm hoping that we can kind of revisit that to kind of block out how much time we're going to spend after we have this list. Another thing I thought it would be important for any process is to have some agreement before we start making recommendations and decisions about what the process of making a decision. We made a few motions last time that were informally amended and that kind of thing, which was no big deal. But as you get to more critical language in this thing, you might want to have some ground rules among the group of how we're going to make and reach decisions and what's the process that we all think is fair. I think that's good to talk about before you get to the point where there might be disagreement, because we're all neighbors. And then I also kind of I've been thinking about the format for the report. Since it is advisory, we may have some decisions that we want to provide an argument along with the report. And in the report that I saw from 2006, it was just pretty straightforward. This is the new language. And we might want to think about, as the council and the mayor review it, what are the pros and cons, and what are the, so what is the discussion behind that, and how can we support with both sides of each argument, so that maybe focusing on the whys we think need to be changed rather than how. And I think I mentioned that last week, but those are kind of some of the thoughts I had about, like, how do we come through this where we all feel like it was a good process and that we gave the city what they needed.
Yeah, I think on your second point, that's why I want to begin developing that list. If we sort of nod our heads, yeah, it goes on the list. When it gets to the part where we're making the decisions, okay, item number 3, it's been proposed that this, we'll have our back and forth discussion, and I would see us actually taking a vote. I agree with you, Terry. I think that whatever report we deliver up to council should have narrative, talking about why we did certain things, and up to and including minority reports. If people feel strongly that against something that the majority of the committee voted on, they should be allowed to put their comments in the report back to council. On that other item, your first item with regard to process, maybe we'll defer that to item 7, because that sort of talks about next steps and that sort of thing. Okay, the floor is open. What do you think about this charter and what needs to change?
Well, I have a question for Bob, real quick. Did you talk to department heads? Does that include police and fire?
Yes.
Okay.
All departments were contacted.
Okay, thanks.
Twice.
Okay.
So agreed tonight, we're not necessarily advocating for things that we'd like to see changed in the charter, but just things that we think that are worthwhile for conversation throughout the process. Is that true?
Yeah, I want to keep the discussion as free-flowing as possible, so go ahead and say it, and I doubt that we're going to wrap the gavel over your head and say you're out of line.
Okay.
So,
well, I actually put together quite a lengthy list that I kept for my own, and now, of course, that'll be part of the record because I made my own notes. But just as I was reading through the charter, section by section of things that I think are worthwhile having discussion on at some point throughout this process. So I don't know if you want me to go through and read through all of those now, or if I should pass my notes around the table, or take them one at a time.
Well, I'll tell you what, and thank you for preparing those notes. But what I might suggest is this, that why don't you pick off a couple, talk about them, then I'll put a halt to it for a second and ask, okay, anything else, folks? And when the room goes silent, we'll go back to your list. And I think the important thing now is to begin to develop the list of things that we are going to want to discuss and make decisions about.
Okay.
So it's almost by topic, but certainly you have a reason for having written it down, so let's hear your thoughts on that.
Okay, well, the first two have already been addressed, the duplication of the sections and applied gender neutral pronouns throughout. But in section 2.1, to change the word majority to plurality to conform with state law, we do not elect our council members by a majority, we elect them by a plurality. The top 2 primary helps ensure most elections are won by a majority now, but if we had a situation where candidate A had 49.8% and candidate B had 49.5%, and we had a write-in with 0.7%, candidate A would win with a plurality. So that's kind of more of just a grammatical, semantical type, or not semantic type change that I think we should discuss at some point.
What was that section again?
It's 2.1.
2.1, okay.
Is that the only place that it applies in that?
That was the only place that was mentioned throughout the document.
Go ahead.
Can we keep going?
Oh,
Okay,
yeah.
I'll keep
No,
going.
I'm not going to. Let's do 2 or 3 at a time here, and we'll get you
So
through.
section 2.5, just asking the group if maybe we should consider defining, putting a limitation to the definition of reasonable time. If we had an incapacity or on the council should we put maybe a limitation of 12 months or some other length of time before a resignation would be required? Because right now it's indefinite the way that the language reads. That'd be section 2.5.
Can you point me to the paragraph?
So it says, it'd be, let me see. Pull mine up.
It's the third paragraph.
Yeah, it'd be the third paragraph from the bottom.
Okay, in the event of extended excused?
Yeah.
Okay.
And actually, it's the last paragraph on that page as well. Incapacity, as used in sections, shall mean unable to perform the ordinary and usual tasks. And then it goes on to define for a reasonable amount of time, but it doesn't really define any maximum length of what a reasonable amount of time is. I guess the concern is if somebody is elected to the council or to the mayor's office and they become incapacitated, 2 months after they're sworn in, we could have a temporary office holder for the remainder of their term if we don't have some sort of limitation to the length that you can have a temporary designate.
So it compels action by the council to, at some period, you gotta get it replaced.
Yes.
Supreme Court comes to mind all of a sudden. I don't know why. But, okay. And unless I hear any counter arguments, it topically goes on the list of things that we'll be addressing later. So, want to take another one? And show your hands if you have something that you want to talk about as well, and I'll make sure that...
In section 5.2, I would want to consider reducing the maximum length of a term for an advisory board from 6 to 4 years. The rationale behind that 6 years is a really long time, and if we were to have a less of a commitment, may lead more people to want to participate, and may lead to less early resignations of people in those positions as well.
It's 5.1.
Okay, what?
Oh, I had the same thing.
Yeah, section 5.2.
And I've got it on page 28 of 62.
Yeah.
Yeah.
Or 14 of 31. Yeah, Jim?
Yeah, the language actually says to a maximum of 6 years, and you could direct less by ordinance, and the city does have an ordinance. Ironically, the ordinance says most are 6 years, but there is flexibility already built in the system to have less than 6 years for what it's worth.
Okay. So it'd be better to lobby the city council on that to remove by ordinance.
Well, they currently have the discretion to change it.
Yeah.
But if in the charter 6 changed to 4, then that would compel a change to whatever ordinances exist at the city to reduce that to 4, correct?
The charter always controls over the ordinance.
Yeah. So, if the majority feels that 6 needs to go to 4, then you should make that recommendation, understanding that that would require changes to certain ordinances in the city.
Yeah, I just think it's worth having a conversation about something that I've served on one of the boards for the last 4 years and noticed that a lot of my fellow members have not been able to fulfill their full term, and there might be some advantage to having a shorter term and allow more people to participate in that process as well. So.
If the group agrees, and that's a valid item for discussion, and it'll go on the list.
I agree.
Okay? All right.
Can I ask a question about boards while we're on boards? Not all of the city boards are in the charter. Is there any reason that they need to be?
No.
Okay. Great.
Could you elaborate on that?
Well, I think when the charter was initially put together, I think there was practice to have certain boards. And I think over time, boards have flourished. And so there are a significant number of boards. And I think there's been seen a certain value to have some flexibility in setting up a board And so most of our boards are established by ordinance rather than by charter, but the charter still does hold a few boards that we're accountable to. So it does, practically, there's not a difference in importance of the boards.
Okay.
I remember 10 years ago, we actually eliminated the Board of Adjustment because I think we had gone to hearings examiner at that point and didn't need that anymore, so it came out. So
That's correct.
Yeah. Terry, did you have a comment?
Well, I was just going to say, the significance of it being in the charter is that it is a requirement of the city that can't be overcome by an ordinance. And so if we were to be able to get a copy of the list of boards, then we'd be able to compare it to what is in the charter to see if there might be a recommendation that there's a board that we as citizens think is important to be in the charter. And the council would have to, of course, agree in order to change that, but it probably would be worth looking at to see which ones they are, and they're not,
So that if for some reason the council someday considered eliminating a committee, if it's mentioned in the charter, the answer to the council is no, you can't do that. But if it's not in the charter, then the council could eliminate that particular board.
Right.
Yeah.
That would be
Steve?
my understanding.
Oh, no, sorry. I think I was just scratching my head.
Got to be careful not to do that. See,
I would just ask, I guess maybe I need some clarification on the difference between an ordinance and the charter. I mean, does anybody else have that question?
Good question.
Yeah.
Jim?
Yeah.
What's the advantage, I guess, for like these boards? I had the same comment too. So what's the advantage of having it as an ordinance?
Well, I think Terry said it quite well.
Yeah.
The charter is the foundational document for the city. It kind of sets the baseline, but the charter also authorizes the city council to adopt ordinances, which then are essentially the laws of the city. And so they also are important, but they do not come about for the most part by a vote of the people.
Okay.
And the charter does, right? The charter's voted by the people. Yeah.
Yes. Does that help?
Yeah, I guess that would be a good conversation for us to, I mean, do we want to have all of the boards listed in the charter and make that change or that amendment, or is it okay that there's a lot of them that are ordinance that the city council controls? I don't know.
Yeah, and I think at this point, Terry suggested that maybe if the committee could see a list of the boards and commissions, then we can go through that discussion and
I think that would be important.
see if something rises to the level of protection through the charter.
We'll get that for you.
Perfect. Thank you. Yeah, Tom?
Do the boards and commissions have the discretion to modify the terms for the participants? It seems like I just got done 12 years on the Traffic Advisory Commission without a year in between, so they were consecutive 6-year terms added onto each other.
Well, the charter does provide that you can't be on the same committee longer than 6 years.
Okay.
I was on the parks for 12 too.
But that could be changed, yeah.
You have a 1-year break in between the terms.
Yeah.
You can do that. You can go 6, 1-year break, 6 more.
Yes, that's the way it currently reads.
Yeah, okay. Okay, don't see hands up right at the moment. Michael?
I'll keep going till
Keep
people
going.
stop.
Yeah,
Okay, we've
keep
got a
going.
bunch in, we'll knock out 5 of them a row here, all in section 11.2 on the initiative process. I think we should look at maybe just the language here in the section is very confusing. I would recommend that maybe we adopt some of the criteria that is required for the state initiative process, such as like requiring 8% of petitioners to sign based off of the ballots cast in the last governor's election, just so it conforms with state law. I would consider removing section D altogether. Sections A through C already outline the path by which the public can file an initiative, and section D, I think, just further confuses the process and is unnecessary. And then just a lot of questions about how I don't recall when was the last time we actually had an initiative in the city of Everett. Have we ever had one? I think that spurs a lot of questions as to operationally, how would we even handle a municipal initiative? How would verifying signatures be handled? I know for a state initiative, it's handled by the Secretary of State's office, but if we were to have one here in the city of Everett, how would that be handled? How would the city pay for it? Obviously, there's legal costs. There's costs of putting the actual initiative on the ballot. Also in 11.2, more of just a grammatical change, but percentum should either have a space in between its two words, or we could just use percent instead. And then also in section 11.2, because we're an all mail balloting system now, we could remove the words including absentee ballots, because we no longer need that distinction between poll voters and absentee voters. So I would advocate
thank you for your time, and that's it.
Thank you, David, very much. Anyone else? Yes, come forward to the mic, please, and introduce yourself, name and address.
Good evening. Sorry I'm late. JT Dre. I live in Everett, and I don't own a car. I depend on Everett Transit for my transportation in this.
Do we have your address?
902 Wetmore.
Thank you.
So I, for the past 6 years, have been trying to have Everett Transit sort of proceed in a progressive way into the future. And one of the hindrances to that, as I see it, is the fact that there is no real board or committee that looks strictly at the issues involved with the operation of Everett Transit. It's a municipal transit system, which is pretty much an exceptional sort of thing. There are 2 others in the state. One of them is in Yakima. But if it were not just strictly municipal, it would be undoubtedly endowed by the state, I believe, with a board or commission that would be involved in its oversight, such as community transit and Metro in Seattle, which is actually for the entire King County, covers the entire King County. It's not 2 separate systems like we have here in Snohomish County with Everett and community transit. So Everett Transit was founded in 1893, roughly. And I'm recommending to you that you recommend to the mayor and the city council that a board be established strictly for oversight of Everett Transit along the lines of the New Markets Tax Credit Advisory Board or the Diversity Advisory Board. I have visited the legal issues a little bit, and I'm not a lawyer and I'm not entirely certain of what's involved, but I'm hoping 1 or 2 of you might step forward and help me with that part of it. I won't sit here and cite chapter and verse for you. All that I'll say is the APTA, which is a national transit organization, recently did review the operations of Everett Transit, and although it was a limited review of their operations, unfortunately, in my view, they did issue some interesting observations, and I'll just quote you and leave you with this one. It was not apparent to the panel that there is a long-term city vision for the future service direction that staff could identify with. Consequently, transit functions are largely focused on survival. That's certainly my experience using the city's transit service, and I think a board would help sort of focus their attention and maybe bring them together to meet the $5 billion that we're going to spend to bring light rail via the Boeing plant to Everett Station. Thank you.
Thank you very much.
Hi, I'm Deb Williams, and while my address is this building, I've been here for, I'm on my 31st year here. And
I think we're going to name it after you, Deb, at some point. So.
What's that?
I think we're going to name it after you at some point. So.
And while I am here at the request of the City Council offices, I am not here with the things that I am going to mention this evening on behalf of the other council members. This is specifically coming from me as an Everett resident. president, and it has to do with the 3 different issues in regards to council meetings. The first one is...
Deb, I don't mean to interrupt, but can we have your Everett address, please?
Sure. P.O. Box 12893, 98206.
Great, thank you.
You're welcome. And I reside in South Everett. The first thing was the non-gender specific that you all were referring to earlier. We call all the council members, and that's how we get away from the councilmen, councilwomen. And so, and I saw sections 2.1, 2, and 3 are councilmen, and then section 2.4 is council member. And so that's what we call them. We call them council members or the council president, and it gets us to not into the men, women, especially considering there are 3 women serving on the council and 4 men serving on the council. Also, there's a section, and it's page 11 in your council legislation, or section 3.2 for council meetings. And this is an issue, and I apologize, because we don't have a department head. The council president, I guess, would be the department head, so we don't usually join in the council or the city department sections where people come and ask you what you think and stuff. So,
did you give us a page number just then, or a section number?
Absolutely. It's page 11.
Okay.
And it's section 3.2.
Okay.
Okay, I'm sorry. This book they gave me is... Okay, so section 3.2, council meetings.
Yep. Okay.
And the very first line says, the city council shall meet regularly at least once each week at City Hall. And the problem that we have is that although in all the years I've been here, we actually only had 1 council meeting where we literally could not meet because of snowstorms and everything, the whole city shut down. We are the only council that is required to meet once a week within the City Hall, meaning we can never not meet every week, regardless of whether or not we have an agenda or not. We must meet. And so having that language at least once each week definitely has raised some concern. So if you could just look at that, would be great. And then the second piece is...
So, Deb, can I ask you a question? So is it more the once each week, or is it more that it's at City Hall, or
the
both?
once each week piece. We are the only one that there's no discretion. We have to meet even if we have nothing to meet on.
Even holidays?
Yes.
Okay.
Once each week.
Yeah, thanks.
So,
When you say only council, what do you?
meaning I checked with we use a lot of municipal research services to do research in regards to what other city councils are doing, whether they are a mayor council form of government or whether or not they are a city manager form of government. And in checking with the other cities to find out, is there any other city that's required to meet each week? The City of Everett is the only city that has that language and is required. There are no dark months. They must meet each week regardless.
So could I ask you, what would you suggest for language then?
Just to take out the language that says at least once each week.
That would just be left open, that they shall meet regularly?
Yes.
Okay.
It gives you the discretion that if you have nothing to meet on. Now, mind you, we always have something to meet on, but like the time that we were caught in the snowstorm and we couldn't, I mean, we have scrapped, I don't want to give the impression that there are not times that we have an agenda that we put it together because we needed something. We have definitely done that. But the one week that we couldn't meet due to the snowstorm, we literally violated what our charter says because we couldn't meet.
And the times of council meetings are set by ordinance, right?
They are, but it's also in the charter that it says 6:30.
No, I know it's in the charter, but if this was to disappear from the charter, council would still have the ability to set their meeting times by ordinance, right? Yeah. Okay.
Yeah, with 3 readings giving the public an opportunity to weigh in. And then the very last thing, we're trying to go to a paperless agenda. We have been working on that quite a long time. Currently, I put the agenda on the web 4 different times, but because the charter in the language that it has, and by the way, this is the same section, section 3.2, there is language in there that says that all meetings have to be published and that they have to be published, and I was trying to make sure that I was prepared before I got up here. It has right here, halfway down the page, it says the public meeting, the date of which is not fixed by ordinance, resolution, or rule, unless public notice of such meeting has been given by such notice to the local press, radio, and television. Well, the problem that we have is that sometimes we don't have anybody, like I have a list of radio stations that when I call them to tell them that we're having a special meeting, they want to know why I'm calling. And so because we put it on the web and because we put it in the buildings and because we put it on the TV, having us required to publish it in the newspaper is an additional piece that sometimes is a challenge.
So do you want radio and television removed?
Or if it could say or instead of and. If you take out the word and, it gives us the, that way, and that's it.
And or.
Would saying to the form of media that would most appropriately reach the broadest, group of citizens and not even be specific to the media type? I mean, why press?
I agree.
I think more general, but to get to the objective of what you're doing in advertising.
To achieve it, absolutely. Yeah.
Thank you.
Thank you very much for your time. I appreciate it.
Okay, thank you, Deb, very much. Dave?
Yeah, I had a question for Jim Miles related to the notice requirement, because I know that doesn't the state law have a notice requirement for press at least one day? Or is it, here it says 12 hours, so what's the notice requirement under state law?
Yeah, I don't know exactly what it is, but a lot of this is already covered in state law. So as a fallback, that's what is oftentimes leaned on, but it probably should at least be consistent.
I think state law is 1 day, that you have to have at least 1 day. I don't know if 1 day is that you can do it at 5 o'clock on the 5th, and then at 5 o'clock on the 6th you can have the meeting, or if it's at 12 hours. But it'd be good to have some input back on that.
So that'll be on the list. The issues that Deb raised, the whole issue of when are meetings held, when and how are they advertised, that'll go on our topical list, along with the transit issue that was raised. And David, I think you're going to find that districting issue might just pop up on the list here at some point soon. Any other comments from the public? Okay, then the public hearing concluded at 5:48. Erica, I'll go to you next, and then Terry.
I had a question about section 15.1. The lawyer and me read the words power to subpoena witnesses, and it's so vague as to what the council can do. Enforce attendance, production of all books, papers, documents, and files. I don't know if this has ever happened before, but there's no procedure by which somebody could object to that or how it would be enforced. And I don't know, speaking with Mr. Isles, has it happened before that the council has tried to subpoena things or people?
I don't recall having that occurred, or having seen that.
Okay, I mean, it might be an issue that doesn't need to be addressed, but I was thinking that there are civil rules that could be referenced that that lay all the details out about, if somebody doesn't want to provide the documents that the city is requesting, how do they respond to that and object to that? I mean, I don't know how the council enforces it.
I mean, yeah.
Okay.
All of the subpoenas and forcing people to bring files and all of that other stuff, I thought that's what happened in court after somebody disagreed with the council and all of that stuff. But point well taken. Okay, Terry, were you next?
Yeah, I just had a question. Especially after last week's conversation on districting, I kind of expected to see more neighbors and people, I know we have one folks, I was wondering if you could review the ways in which this meeting was advertised, just to get an idea of how many people are concerned about this issue, or I just was surprised not to see more people speaking out on that.
We put it out on all of our usual channels. What we did is we put a press release out to the media and spread it as far as we could go. Megan Pembroke, our media or public relations and communications director, actually tried to talk the Everett Herald into doing a story. She offered up some of you folks for interviews, and the feeling was that until there's an issue that's really started to be debated, and I guess they want the districting issue to go farther or something, that they're not interested yet until you all get your business going. So that we didn't get the publicity that way.
Right.
I know KSER was running notices of the meeting. We put it on all of our internal stuff, the website. It was very prominent on there. We did a couple boosted Facebook posts, which are well read by folks, tweeted it. Like I say, on the website, it was the lead slideshow image for quite some time. So that was about it. There was some mention by the mayor at the Association of Neighborhoods meeting to try to spread this around.
Specifically wondering is if the Office of Neighborhoods and all the chairs of the neighborhoods had received notice of it. And then this was the
they had at the meeting.
piece of feedback we got?
That was it.
Okay.
Yep. My hope is that once you all get into this more interest will be forthcoming.
Or maybe it's not an issue of concern.
Yeah, that's not too likely, but.
Okay.
Okay, Tom, you look like you're raising your hand there, and then I'll get back to Michael here next.
Yeah, I don't know how much we need to talk about it, but I mean, so this is something that David talked about in the public hearing, and then we got this on the internet, and then I've had a number of people talk to me about districting.
Yeah, we're going to talk about that in just a bit.
And I know Megan Dunn is our subject matter expert on this. So, okay.
Yeah, Claire?
Since we're going down Michael's list, I want to drag you back to Section 1. In Section 1.5, Intergovernmental Relations, glaringly absent from the list of governments the city may do interlocal agreements with are Native American tribes. I think that needs to be added, however it's appropriate to do so.
Okay, other comments? Michael, you want to tick off a few more here?
I just had a question about Section 7, why the library is governed differently than other boards and commissions.
I have that in my notes too.
Okay, and I'm just, I'm not saying that it shouldn't be, I would like to know more about the rationale behind why they're carved out a separate section and have a board of trustees versus the way that other departments are run in the city.
The library is really a creature of state law, and they're controlled under state law, and they have a board, library trustees that really act as their controlling body, and their relationship to the city proper is really the budget. But they're pretty much independent of the city except for the budget, and that's by state law.
Is it a library district or?
No.
And state law mandates that all public libraries be governed this way?
I don't know about all, but certainly ours. Yeah. And we can get you more history on that if you'd like.
That'd be interesting.
And I, just anecdotally, I remember several years ago, there was an issue as far as, between the city administration and the library board having to do with certain things that maybe would fall under the category of freedom of speech and those sorts of things, and it got rather contentious, and I think the library board today would tell you that they see a need for that independence. Now that, like I said, that's anecdotal, and if it needs to be reviewed or changed or whatever, but unlike the initiative issue, that's one episode I can remember that did come up where the charter was asserted. Joe?
Yeah, so just to go a little bit further, point 8.1, the Civil Service Commission, is that kind of the same idea? I mean, I've never heard of that. Is it?
Yeah, it's also a creature of state law.
Okay.
Yeah.
Okay, Claire, then we'll go back to Michael.
3.4, next to last paragraph. And I think this is the next to last sentence in that paragraph. An ordinance which grants, reviews, modifies, or extends a franchise shall take effect 30 days after the date of its becoming valid, unless a later date is fixed therein, at which event it shall take effect. It says as such later date. I think that's intended to be at such later date.
Mine says that.
Mine says as.
Oh, really? Okay, I'm reading from the one that's got the double entries of everything.
I'm reading from
Maybe
another
that
one,
got
and it
changed.
says
Sounds like it'd be nice if we all had the same document. Maybe there would be.
Are there members who have a copy that says at?
Mine says at, the one with 39-page one.
Shall take effect at such later date.
Yeah.
And his says as.
Ours says, mine says
Well, there's two different places, but that's it.
Oh, maybe that's it.
There's one up in the second line and there's
Oh,
one in the
as.
fourth line.
Excuse me. Yeah.
So when you're giving a page number, tell what version you have.
So I am being corrected. Up above it does say as, but down below it says at. So that is accurate. Sorry.
Okay.
So for the notes, it's section 3.4, is that right?
Yeah. Terry?
I was just wondering, and I think you guys talked about in 2006, maybe one of the meetings was just walking through each section and talking about it. And I was wondering if maybe if we either use the city's attorney or an attorney that specializes in this area of law to look at what the state already covers. And I wouldn't see any reason that you would want to duplicate that in the charter, because then as that law changes, this law becomes outdated, and then there's a conflict between them. It seems like there's a number of places where we're talking about the state law, talks about it already. So I would wonder if there's a way to just kind of eliminate anything that's already in state law, specifically addressing what's in the charter. If when we do have an attorney available to us, we could walk through the whole thing and then look at those sections that are already addressed in state law to see if we could recommending making this document more manageable and more current without having to do a vote.
Jim, do you have a comment on that at all?
Well, I think it's the 24th. Yeah, 24th. We have scheduled an attorney from Municipal Research Services to come and provide an overview from his perspective of our charter and charters in general. And he certainly will be available to answer any questions that we might have. He will not be prepared to address the issue that Terry is raising. So.
You say will be prepared to talk
No,
about.
he would not be.
Would not be.
That'd be above and beyond what.
Because I think the question is, do things in state law supersede local government, if you will, to the extent that anything we would put in a charter wouldn't really have any effect. But I've also seen situations where they say this is the general rule. If a local government wants to be more specific than that, they have the ability to do that. So I think it's a valid topic to take up, and just because if we can avoid redundancy in the charter because other things take precedent, then, maybe that's what we want to do.
Or possibly conflict.
Or conflict, yeah. Yep. So at some point, and we probably need to be somewhat specific on the ones that are of concern to us, but maybe that's where we turn to the municipal council, contract council, and talk to them about it. So, but let's see where we go on the 24th. Maybe they will have some opinions on that.
Well, I think the other thing that he could provide is a certain level of confidence in what other jurisdictions are doing, and if in fact we are parallel or if we're off course.
So that'll be noted on our list, but Terry, your assignment is to raise that question when municipal research is in the room.
I shall.
All right, good. All right. Okay, Michael, let's go back to you.
I would defer to anybody else.
Well, no, I'm doing that for you.
All right, okay.
Yeah.
So section 5.2, the very last sentence, no elected official of the city or appointed city officer shall be eligible for appointment to serve on advisory boards or commissions. That used to say or city employee, and that was removed back in 2005, which I think is a good thing. But I think we probably should add one caveat, in that a city employee would not be eligible to serve on a board or commission performing an advisory role for the department in which they work. I think it's common sense, but it probably should be codified in the charter, because we wouldn't want a situation where a park ranger is, is serving in an advisory capacity to the board of park commissioners. But that same park ranger would be more than eligible to serve on the Diversity Commission or Transportation Advisory Commission.
Okay, valid. Let's, without objection, we'll put that on the list of things to discuss.
I have another one for that section. It's okay.
Yep, go ahead.
So under maybe 5.1, to have some language in there, and this is just for discussion, that members of boards and commissions reflect the makeup of the community in regards to age or gender, race, and geography.
Could you do that one more time, Megan?
So just to discuss that, let's see.
This is 5.1.
5.1.
Yeah.
Yep. Okay.
That, so people appointed to boards, commissions, committees, or other such bodies reflect the age, gender, and geography of the city.
Suggestion. Might that be something that we talk about under 5.2? I think the intent of 5.1 is to say whatever boards recommend, they're only advisory. I think where we talk about establishment of boards, maybe that's where we can get into the geography and the gender and race and those sorts of things.
Okay.
But let's talk about that as a topic, and then we'll decide where it goes. So.
I'm all done.
Whoa, gee whiz. Well, good for you. That's great. Any other, we're going to be talking about the big one here in a second for a little bit. Any other comments from members?
I wanted to come back to one of Michael's around, if we're going to be looking at 11.2 in the initiatives, to make sure that military ballots aren't excluded. I don't know if those are considered absentee. So if you strike the word absentee, are we excluding military?
No, they would be included because everybody's absentee.
Okay.
Now, this is the way I would read it, and I think it's worth bringing up when we discuss.
As long as they're not.
Yeah.
Okay.
Okay. All right. Hang on 2 seconds here. We got. Okay, I want to reserve some time to talk about Terry's first issue with regard to process, so that we make sure that's covered. And we've got 25 minutes left. So if I could, I want to raise the districting issue. And I would like to just get some comment around the room as to how the committee would like to approach that topic, what information you feel that you would like to see, and if anybody wants to add some definition to that topic so that we get focused as everybody wants to be, we can do that. But I'm going to assume right off the bat that districting goes on the list. And, yeah.
I just have a question, because focusing, you're using that term, I wonder if we're actually starting a little bit too focused. Because I've done a little bit of reading about what other communities have done when they've explored this issue, and they've actually started broader. I mean, so you look at like Pierce County, by example, they have the ranked choice voting method that they use down there. So I'd be curious to kind of look for experts that we could have come talk to us about elections in general, processes and the different choices, pros and cons, not just districts.
What was the term you used for Pierce County?
Ranked choice voting is what they have. So what they have is they actually have a list, and then you vote based in order. So you don't actually have positions where people run against each other. They all run at one time. I'm not saying that's the best one. My point is simply having a broader conversation.
I see. Everything's at large, and the top 7 vote getters are on the council or whatever.
That's right.
Okay, okay, thank you.
I guess along those lines, I had a similar question for information from the county assessor about how many people have attempted to run from other districts. Is there a history of elections failing because people are running from other districts? Is there this groundswell of interest from other neighborhoods within the city? And then also kind of wondered from the Office of Neighborhoods, how difficult is it to fill positions, sort of along the lines of what Megan raised on, requiring the city council to have committees reflect diversity or reflect any particular metric. You can't make people apply. So it's more of a strive to do that or seek to or give preference to or something like that. But I guess I'd like to have more information about knowing it is a problem. I think intuitively a lot of people think districting is always an answer. Having come from a community that had districting and seeing elections where we're won and lost by 5 or 6 people instead of, you ended up with a kind of a different problem. And so I support the values that we're talking about in these papers and really the effort, but I'd really like to understand more about, is it a problem here? Are there steps to prepare a community for districting that will make it successful, maybe starting with the Office of Neighborhoods or, more information about that. So I would really support and second Chris's suggestion to have a broader conversation and really understand, what's working, what's not.
And point well taken, and I should probably emphasize that what we're discussing now is how do we approach the topic of districting, and I don't want to leave the impression that members of this committee are somehow barred from recommending don't do it. That's the very vote that we're aiming for as the committee as we move this thing up to council. And I agree with you, Terry, the more information that you people need in order to make first that, mainly that yes or no recommendation, that's what we want to hear, the things that you want to see. And I think you listed some of them. Is the municipal research folks, are they in any position to talk about that when they come up? What other communities have done? And
yes.
Okay. Is that their principal reason for coming up?
No, I think the principal reason is one, they did it last time, 2006.
Just the whole charter thing?
Yeah, I think it was more to give just a basic framework for what charters are and basically what they look like and the function and what you can expect. And so I think the districting issue happens to fit that discussion pretty well.
Good.
And so they are prepared, they will be prepared to address it generally.
Good. Excellent.
Is there a county elections office that could speak with us about
the history in this community, or that would be another resource. County, Snohomish County.
History of
Voting patterns that show that we are not electing people from different communities.
Oh, I see. Okay.
Great. One thing I'd ask Jim, if we could, is I think there's 5 or 6 cities in the state that have repealed districting. Okay. And it'd be interesting to see what information we can get from those cities, but I think Municipal Research probably would be able to comment about that too.
Yeah.
So,
Claire?
I really appreciate the report that was sent out on the redistricting issue. But I was wondering, when I looked at the 5-district map, it appears that that's based on population. And I was wondering if there were any statistics that went along with that would show within those districts as drawn how many registered voters there would be in each, and how many of those registered voters voted in municipal elections, maybe the last two or whatever, municipal elections.
That's a really good question.
Yeah, so I had asked UW Professor Emeritus Richard Morrill to create the map, and I asked him to build it around existing neighborhoods, but he also took census tracts, which also in some ways relates to zip codes, which is why in some cases it's across the street. You could be in a different census block, but so in that way it's based on population, and the districts there are around 22,000 or 20 to 22,000 in each district. But I think the map is a jumping off point, because I think there's a big difference between east and west in North Everett, and I believe he cut up part of the Lowell neighborhood. So there's definitely some improvements that could be made to the map.
Question I have to no one in particular, so I guess it goes to you, Bob. The duty of this committee, as we're discussing right now, is to come up with a recommendation to council on whether a charter amendment is put before the voter to ask if districting should occur, and nothing else until the voters say, yes, we want districting, and then trying to think of the word, but a committee is formed to actually do the districting, and then that result is presented back in some form. Or is this committee to answer 2 questions? One is, should districting be put on the ballot? And 2, what districting concept should occur? And I'm sorry, I'm being vague there, but and I know that it's all one person, one vote when you form that committee and say, okay, here's what this year's district looks like. I think you have to update it every census period or something like that. Or you could say, yes to districting, and 4 will be at large and 3 will be by district. Do we recommend that to council? Or so is the question districting, or is it, do we need to be recommending more than that to council when the time comes?
I'm sorry to give you no answer in particular, but you all have a clean slate here. You can do anything you want. So there is really no answer to that question. The answer has to come from you all.
Okay.
About what you want to do, how you want to approach it, what you want to recommend to the council.
So one of the matters for discussion by this committee is what are the levels of recommendation that we want to take up to council. And assuming the answer is something other than don't do it, I mean, that could be it, but if that's not the answer, then we need to consider what additional level of detail of recommendation do we want to present. Erica?
Did the 2006 charter review address this topic at all?
in great detail. Yeah.
If I can just again briefly revisit history, I remember the night that we voted on the final recommendation, and if I can call out my great friend Phil Bannon, I posed the issue of districting, and I looked around the room and said, I'm assuming this is a sinking ship, and Phil's comment to me was, Reed, I think your feet are getting wet. So, and that was the last we heard about districting 10 years ago. So, yes, it was taken up, but it didn't go anywhere.
There's
Derek?
a lot of information.
You just said that we received direction from council to evaluate districting. I was really hoping we were going to get some kind of written document or minutes or something that was what the council talked about in forming this committee. I know it's required, but were there specific instructions to us from council?
My recollection is that some council members thought that this would be more appropriate for charter review than for a vote, but I don't think there was ever a vote taken that actually provided specific direction.
On the night this committee was confirmed, was there a discussion about what they hoped?
No.
So there is no, this is simply...
There was a districting. In fact, it was when Megan made the presentation, I believe, was that night in September.
In September.
Right, and then there was a long discussion amongst council that night. Some council members thought that charter review would be the appropriate forum for the discussion, but that's as much direction as was ever
and none from the mayor
discussed,
either,
and it
so.
no, and it never came in the form of a formal vote.
And that's your recollection, Megan?
Yeah.
I was just going to add one more thing, is that it looks like Megan spent a lot of time and energy on this, and I noticed that she didn't testify. I don't know if that is it appropriate to build it into our schedule, that she'd be able to present her whole report so we could hear all of it. I mean, I don't think just reading it is enough to really hear about it. So I think that should be one of the things, is have her, I wasn't able to hear her original presentation, so I'd want to hear that.
I did it in 5 minutes.
We'll give you 6.
Yeah, right, to
I
expand.
got 2 extra minutes. No. Oh, yeah, I'd be happy to do that.
No, that's great. Okay, other comments?
I feel obligated to raise one other potential issue for discussion, and I don't know really where it belongs, but I suspect that it belongs in section 14, either 14.2 or 14.3. Under state law, the city is allowed to impose a tax on foreign utilities, for lack of a better term, that operate within the city limits. I suspect that the charter sort of viewed that as a franchise issue, but it appears to me that it really fits in the finance and taxation issue. But what I'm trying to get at is with regard to its own utilities and other enterprise funds that the city operates, there is no such limitation on how much the city imposes in the form of a tax, but it's usually characterized as a payment in lieu of tax from a city enterprise fund to the general government for the privilege of operating the enterprise within the city government. And I would like to offer the possibility that the charter include a limitation on that transfer payment, that it be not greater than the highest utility tax rate authorized under state law for cities of the first class. Some way to
So are you talking, Claire, about the
payment
assessment
tax
from our enterprise funds to the city for all of the services that the city provides?
No, it's just strictly the payment in lieu of tax, because there's also transfer payments for specific services performed by various city departments for other city departments.
Claire, that's, I'm going to take a guess that that's pretty esoteric in the minds of a lot of folks. Could you, just by way of example, and I think it should go on the list for discussion, but enterprises, utility, and all that other stuff, can you, we've got water districts, like Silver Lake Water District. The city operates its own water system. Can you draw an analogy between?
The better analogy is a telephone company, a cable company, a private telecom company. Generally, I don't believe the city can tax other municipal entities. So there's, I don't believe they have the right.
Like a water district.
Yeah. Is there a utility tax on the PUD?
Yeah, I think there is.
Okay, so the PUD was not exempted from that because many electric utilities are private. But that tax is limited in state law. I think it's currently, the highest rate's currently about 6%. Which is equivalent to what the current payment in lieu of tax rate is that the city applies. So it wouldn't change what's currently being done. It would merely limit it from going above whatever the state authorizes the city to tax other utilities at.
Really silly question. Who's our current utility director at the city?
Dave Davis is the Public Works Director, which includes the utilities.
Could I suggest, it will go on the list for discussion, but could I suggest that that maybe you could talk to Dave Davis and clarify that issue for the committee?
It's probably more of an issue that would be in the purview of the city's budget director.
Okay, finance director. Okay. But I'm trying to figure out how we can, what I hear is something's being capped at a state rate.
Yeah.
But if this committee is going to make a recommendation on it, and I'll include myself in the group that needs to understand what it is before I can vote on it.
When I looked at this statewide, admittedly many years ago, because I haven't worked for the city since 2001, it turned out that these payment in lieu of tax rates ranged from 0 to the low 20%. 22%. When I shared that data with all of the people who allowed me to have that information, the two outliers that were over 20% got their rates reduced to something more in the range. But the typical, the average across the state was about 6%. And most of the ones in Snohomish County are in that range.
Bob, could I ask that you and Claire work together to maybe involve a Dave Davis in that conversation, just to educate the committee coming back on...
or someone from finance, right?
Finance.
Finance, I'm sorry. Yeah, finance. Sorry.
The whole topic of finance is an area that, we might want to know what standards are. And, like I know that a lot of jurisdictions are adopting financial guidelines about how much debt capacity and coverage you have. I think it'd be interesting to hear from the finance director or however it works.
Is that Deb Bryant? Maybe have Deb come and speak to the group about the whole finance issues, specifically with regard to the charter, any improvement sort of thing. So maybe we can put that on a list of...
Well, she did recommend the warrants and the elimination of the banks, and that was her input on what she thought needed to be changed.
But Claire's raising an issue that I'm not sure that Deborah...
Right. All I'm saying is I don't think Deborah would... I thought you were going broader than that for a moment. And absolutely, we can work on the issue that Claire's raised.
This is beyond anything the staff would have brought up, I'm sure.
Yeah.
Claire, are you saying that in lieu, in lieu of tax, that a non-government, it's a government, but it's not a general government, city department like utilities, can't be assessed at a rate any higher than the state allows?
Yeah, I'm suggesting that the payment in lieu of tax portion of the transfer payments from enterprises to the general fund be limited to that which that tax level that the city can impose on anybody else.
If this ends up going to the voters, you're going to write the ballot section on that one. So, and cartoons will be allowed.
I think the simplest way to describe it is it would limit the city's ability to tax its captive enterprises at the same rate that the state allows it to tax other enterprises.
All right, it goes on the list as a topic. We've got 5 minutes left. Joe?
I just have a suggestion from our last time we did this, me being really sequential. I liked going through it chronologically here, and now that we have our list, and when we get to the points, maybe if I could suggest that we try to look at the document that way, and when we come up to one of the points that we want to talk about, we talk about it, so that we can move through the document rather than going all over the place. I think it was great to get a list, but I think I would like to suggest that maybe we need more things to put on the list next meeting, but eventually that we get down to where we just kind of go through the whole thing and figure out what do we want to add, delete, or talk about, if that works.
Okay, we've got 5 minutes left. Terry, would you mind revisiting point number 1 on that list of 3 that you had regarding process and meetings? And I want to make sure your points are addressed.
I think I like what you said about having our recommended language be supported by an argument and a minority argument, because I think that is the most informative for the audience. So I like that answer, so I don't know if everybody liked that. And then I also thought we should talk about, are we going to adopt sort of Robert Rules of Order for how we make final decisions on language, and are we sort of all in agreement in that, or is there anybody that thinks we should do something like a consensus vote? Or I just want to make sure that everybody agrees going in how we're going to make decisions, so that no one feels bad or feels like it was manipulated or anything like that in the outcomes. So that was just my concern, is I always like to make sure we're understanding how decisions get made.
Yeah.
So
So I think once we have our topic list, and Joe, you're dead on target there. I think what we do is then we go through section 1 to section whatever and raise these issues, talk them out, and no final decisions, but a tentative list of pros, cons, opinions, and all of that for that list. Ultimately, I see us ticking through a list. All in favor, aye. All opposed, nay. And then the next go-around, we actually see that reflected in a draft report with the narrative and the minority reports, if that's what we want to do. And so that ultimately, what's our deadline, June 1st? June 1st. Somewhere right before June 1st, we all look at it and say, all right, is this it? And if so, we take a vote on that, and that's what moves forward. So if that sequence makes sense, and that's the way we'll proceed. Jim?
Just to remind you from the discussion we had last time, for an item to move forward, it has to have a support of at least 10.
Thank you.
Okay, how many do we have?
15.
So we're at 2/3.
So that's more of a consensus decision-making process then, than just majority rules?
So we would take that vote on each item, and if something fails for lack of 10 votes, then those that lost the vote, if you will, they have the ability in the narrative that's developed to put in their minority report. Okay?
Sounds good.
Okay. All right. Anything else for the good of the order that we can tackle in the next 58 seconds?
As far as dates of future meetings, right now we have blocked out the rest of the Thursdays in March. Just If the group wants to stick with that, we'll stick with that. We have municipal research coming on the 24th. But if there are other specific topics you want for the agenda next time on the 10th,
I think there may be other things, and what you'll see me do each meeting is I'll say, are there any items that people want to add to the agenda for tonight? But as we roll through this thing, I really think the agenda next week and the weeks after, agree to the topical list, have the discussion, go through the report, take the votes, and if something else comes up where, okay, hold it, we got to discuss something important here before we get back on that sort of review, then we can certainly do that. But I say let's roll forward and just start getting this thing done, because, boy, June isn't that far off. The one suggestion I would have for the agenda, if maybe right at the beginning we can take time for any member of the audience that wants to get up and make a brief comment, not a public hearing, that'll come later, but just public comment, and let them stand up, say their piece, and we go from there.
Sure.
Anything else? But we are going weekly from now on, right? Okay.
So are you saying you want to go weekly through the end of May?
Number one, my own personal view is I think that, yes.
Okay.
Maybe towards late April, say, gee whiz, we sure have worked hard and we don't have that much more to discuss, so let's meet in 2 weeks.
Well, we will proceed then from the assumption that you're meeting every week and get that set up. And then
Okay.
if you want to back away from that at any point, you can.
And does everyone agree with that?
Yeah, it really makes sense to try to roll through the whole thing sequentially and then sort of table those bigger items and then save that for like April and have a lot more time for those. So I like
Take care of the minor stuff,
Yeah.
so-called.
and figure
then,
out what is left.
Yeah, and on that districting issue, quite frankly, that takes time, and we're going to want to do our due diligence on that. And so, okay, that's how we'll proceed.
And maybe if we're not going to have a quorum with, like, in April, there's spring break. So if anyone has travel plans, and we know in the future, okay.
What
week is it?
It's the first week of April is spring break.
What, if anything, do you want us to do within this next week?
I would say the sooner that we can get the list of topics out to everyone, then I think homework between now and a week from now is for each of you to go through that thing and form your opinions on each of those topics. And the bonus homework assignment is to, if you see a topic, then look it up in the charter itself so that you're conversant with the context of that item within the charter itself. And maybe, do we need to run, sorry to kill a tree, but do we need to run a clean copy of the charter that's got all
We'll
the
do
page
that.
numbers?
We'll do that,
correct and all
yes,
stuff?
absolutely. And then one other reminder, you'll look at your agendas closely when you get them, because we're going to bounce around from room to room sometimes.
Oh, okay.
We don't have this room available every week. We don't have some of them will be back on the 8th floor where we were last week. So always take a look. They'll all be in this building. That's the good news.
So in the interest of public openness, we're not going to tell people where we're meeting.
Well, it will be on the agenda, which will be on the website.
All right.
Next week it's here. Next week we've got this room.
Oh, it's here? Okay, good.
I don't mean to nitpick, but if we have handouts, is it possible that they can be 3-hole punched so that we can put them in the binders?
Okay.
Thank you.
Good point.
Thank you.
Read 4:30.
All right, everyone, thank you very much. We'll see you at 4:30 next Thursday in this room.